Thank you very much for having me. It's a great pleasure to be here and an honor. I thank the organizers for including me in this event. I was going to make some comments under three headings. First of all, outline the distinct features of the EU legal system, although Professor Barnard did that in a much better way than I would hope to do it. Say a few things about attributes of arbitration resolution systems in bilateral investment treaties, and then provide an overview of the kind of dispute resolution systems included in EU international agreements. The third one is part of a research project that I am currently undertaking. So the first point, and just complementing what Professor Barnard said, what is distinct about EU law? And I think there are two elements. One is this idea of direct effect, the ability of individuals to enforce EU rights before national courts. And secondly, the interjudicial dialogue. The EU law is integrated into national law, and through the preliminary reference procedure that Catherine mentioned, there is a dialogue between the national judiciary and the European Court of Justice. So the combination of direct effect on the one hand and the judicial conversation gives to European Union law an immediacy which is similar to that of national law. So in a nutshell, if one were to ask me what is distinct about EU law since the establishment of the European communities, I think what is distinct is that it abolished the monopoly of the nation state to grant rights. This is what EU law has done. It has separated itself from international law. This idea of giving rights to citizens is no longer the prerogative, the monopoly of state power, but it has become part of a supranational authority. And I think this is the distinct feature of EU law, which then leads to, if you wish, a hybrid system for judicial protection. It has some elements which are based on national law, some elements which are based on EU law. The two are integrated, leading to the hybridization of remedies, of enforcement of judicial protection. To put it in another way, some 25 years ago, Judge Mancini, a member of the European Court of Justice, encapsulated the distinct character of EU law by saying that this principle of direct effect, which is in itself a product of the case law of the European Court of Justice, took the law from the hands of the bureaucrats and gave it to the people. And I think what Brexit does is to reverse that process. I think what the government wants to do is to take the law from the hands of the people and give it back to diplomats, to bureaucrats, increase the discretion at governmental level, lower the remedial effect of EU law. So if we look at other international agreements, what kinds of dispute resolution mechanisms do they have? I'm only looking at so-called bilateral investment treaties, and outlining very briefly what the basic features are. I'm afraid I don't have any slides. I'm the only PowerPointless member of the panel. Bilateral investment treaties include essentially two kinds of arbitration mechanisms, of dispute resolution mechanisms. One is the so-called state-to-state arbitration, where one of the contracting parties can take the other contracting party to an arbitration tribunal. The other method of enforcement, which is quite usual in bilateral investment treaties, is the so-called investor-state arbitration, which enable a corporation from one of the contracting parties to sue the other contracting party, to sue another government, in other words, not before the courts of that government, but before an arbitration tribunal. So we have state-to-state arbitration and investor-to-state arbitration. The agreements tend to contain various limitations, limitations as regards who can bring proceedings before the arbitration tribunal, limitations as to the subject matter and the scope of jurisdiction, limitations as to the timing of jurisdiction. And also they do not tend to have any specific rules on procedure for under which the arbitration tribunal will work. Also, very few of these bilateral investment treaties contain any provision on interim measures. Interim relief, i.e. the relief that the party gets until final judgment is given, can be, for lawyers, for parties, very important in practice. They differ from the European Court of Justice and the system that applies in EU law in a number of respects. The European Court of Justice is an international court. Arbitration panels are considered alternative dispute resolution mechanisms. The European Court of Justice is part of a constitutional system of multi-level governance, if you wish. Bilateral investment treaty tribunals are not parts of any such system. There are differences, very important difference in relation to access, who can access the court, in relation to the scope of jurisdiction of the judicial body, in relation to the process guarantees, the procedural guarantees that may exist, and also many differences in the relationship between the arbitration tribunal and the national judicial system. As I said, in the context of EU law, the EU judiciary and the national judiciary are integrated. Just a bit of road mapping. One can trace 110 bilateral investment treaties concluded by the United Kingdom between 1975 and 2010. Some of them are terminated or no longer in force. All these agreements are pretty narrow in their economic scope. Interestingly, they don't protect things like sustainable development or human rights. Those that protect labor standards have an EU element into them. So those that come from the UK tend to be heavily focused on economic matters. It appears that the United Kingdom has been involved in 58 investment disputes under those agreements. In most of them, it has been involved as a claimant. So it is the government that takes the other party to the court. There has been only one known case. The difficulty with these cases is that they are not necessarily reported. So we don't have a full picture. So there is only one case where the United Kingdom has been the respondent, has been the defendant, but the outcome of this case is not public. That gives you, of course, as Catherine said earlier, and as the white paper of the government provides, you are looking for something new, precedents, previous practice or previous models will not necessarily prove appropriate for what is to happen in relation to the dispute resolution system that will be contained in any future trading agreement with the EU. So in this relation, I suppose in this context, one could identify various options. There could be an agreement with the EU with no dispute resolution system at all. I think this is unlikely, and it is unlikely first because the government in the white paper states that it wishes to have one, and certainly the EU also would be in favor of that. The third point in the presentation, allow me to say a few words about a research project which I am carrying out. It's at an early stage, and what I'm saying is based heavily on my colleague's work, Georgia Sangiolo, who is present in the room, and she's carrying the research project with me and has done an enormous amount of work on this. What we are trying to do is this. We are trying to look at the international agreements, trade agreements concluded between the EU and third states, and try and map out what kind of dispute resolution systems exist in those agreements, and see how they have evolved, try and find if there are any patterns that we can distinguish with a view to informing ourselves about the conduct of the EU, the practice of the EU, how does the EU view dispute resolution procedures in its external relations, and also to see how that might perhaps play a role in any future agreement that the United Kingdom will conclude with the EU. We are looking at a total of 91 agreements concluded by the EU. The overwhelming majority of them do include a dispute resolution mechanism in the form of an arbitration, a quasi-judicial procedure. Very few of them, about 8 of them, only provide for a political mechanism. The basic trend, I think, is that there is a direct link between the remit, the breadth, and the complexity of the agreement on the one hand, and the sophistication of the dispute resolution mechanism on the other. The more areas the agreement covers, the more sophisticated, the more detailed that the dispute resolution mechanism is. So political agreements that have a framework nature, or purely sectoral agreements, tend to have very brief provisions on dispute resolution mechanisms. By contrast, those agreements that provide for market access, that provide for trade liberalization, that provide for a degree of harmonization among the laws of the contracting parties, tend to be backed up by sophisticated mechanisms. One aspect which I think is important to bear in mind is that the external trade conduct of the EU is conditioned by its commitment to advance its values and protect fundamental rights in the international plane. Article 21 of the Treaty on European Union states that when it pursues external relations, the EU has to promote the policies of democracy, the universality of human rights, the rule of law, and this has, we think, inhibited the European Union in the kind of partners with whom it might conclude international agreements. That, of course, would not have a bearing in relation to the United Kingdom, but I think it is important to bear in mind. So what sort of things are we looking at? Well, we are looking at the selection and composition of the arbitration tribunal, the number of arbitrators that may be required. Generally, the higher the number of arbitrators, the more independent the arbitration tribunal is considered to be, because it reduces the exposure factor. There is a collective body that takes the decision. We are looking at transparency. This is an important consideration. It is not to be taken for granted in arbitration tribunals, but if one identifies a trend over the years, is that there are increasingly transparency provisions, and by transparency I mean the obligation to make the ruling available or to make the ruling of the arbitration public, the obligation perhaps to make the hearings public, and so on and so forth. Another aspect that we are looking at is third-party participation. Who can appear before the tribunal, whose voice can be heard? This is important because the more comprehensive the agreement, the greater the range of interests which are being affected directly or indirectly, and therefore the greater the resonance, if you wish, and the impact of the agreement. So, in a nutshell, as I said earlier, what we are seeing is a trend towards greater judicialization of dispute resolution settlements in international agreements concluded by the EU. And of course, this is important. It is important for two reasons. First of all, because the greater the degree of judicialization, the greater the effectiveness of the reciprocal commitments undertaken by the parties. Secondly, the more the greater the degree of judicialization, the more the agreement and the decisions of the tribunal contribute in shaping the domestic system of governance. Just like the European Court of Justice has had an impact in the development of EU law, if you have arbitration tribunals which deliver rulings that are transparent, that they are bound by certain process, independence requirements, substantive requirements, the more it is likely to affect the development of the law of each of the contracting parties. Thank you very much.